So EJ, one of the things that really the advocates for sexual assault reform have a problem with is the fact that soldiers are not in confinement awaiting trial. And they point to what happens in the civilian world, that most of the time somebody's in jail awaiting a trial. Is there a system of bail in the United States Army?
Well, it's not exactly bail, but there is a way to get someone released from pretrial confinement. Now, pretrial confinement is exactly what it sounds like. It's, the commander wants to lock up the soldier or, the service member awaiting trial prior to trial. They have to have a few things before they can do this.
What are the standards for pretrial confinement?
Okay, basically they have to reasonably believe that the service member is a flight risk. That means that they think he's going to run away. Or that the service member is likely to go out and commit serious misconduct. And that means serious. That means they're going to go kill somebody, or they're going to go rape somebody, or they're going to go maim somebody. It's got serious misconduct, and there has to be an actual likelihood of that. They have to have a reason for thinking that. They can't just say it. So those are the two standards. They have to have one of those things before they can keep someone in confinement pending trial. On top of that, there's one more requirement, because the third rule is that you have to have one or both of those things, and lesser forms of restraint are inadequate. That basically means they can't try anything else because it won't work. They can't put a guard on the service member's barracks room. They can't, just have them sign in every 2 hours or anything like that, because they don't think it'll work.
Well, isn't there a huge difference between the civilian world and the military world? I mean, in the military world, aren't all military personnel subject to the orders of their superiors?
That's right.
And aren't they expected, by and large, to obey what their superiors tell them to do?
They are. Mm-hmm.
So if they're told, hey, you need to show up for trial, there is a little more motive for them to do it, say, than a civilian who might flee the jurisdiction and go to a different jurisdiction.
That's right. And that's why a military judge once told me a long time ago, the default is soldier on duty, not the soldier in confinement, because the soldier on duty is expected to obey orders and can be reasonably expected to be a little more likely to stick around for the whole trial.
It's been my personal experience that pretrial confinement is the exception, not the rule in the military.
Exactly.
I tell you, in the number of cases that I've defended as a civilian military defense lawyer over the course of the last 10 years, none of my clients have been in pretrial confinement. They've all been subject to the orders of their commanders. How many people, what percentage would you say of criminally accused in the military wind up in pretrial confinement?
From what I've seen, it's a fairly small number. There aren't many occasions where the command decides to actually put a soldier in pretrial confinement. It doesn't happen that often.
In the civilian world, if a civilian judge orders you to go to jail, they usually set a bail, right? A bail or bond at $5,000, $10,000, $100,000, $1 million. And then if that individual can pay whatever that bond or bail is, then they're released.
Right.
So if a soldier's ordered into pretrial confinement, can they post a bail or bond and get out?
That's not really a thing in the military. They're basically, they're subject to the same standards as everyone else. So they either, the command actually has to prove that confinement is warranted.
All right, so once a soldier's ordered into pretrial confinement in the military,
right,
they're not coming out unless the defense counsel goes and makes a persuasive argument to the command or to a military judge if they have jurisdiction,
right,
as to why they should be released. Is that true?
That is true, yes. The command basically has 7 days to hold a hearing, a pretrial confinement hearing, where the defense counsel goes in and essentially argues for release, saying command did not meet the standards here, and the soldier should be let out. If the magistrate, the military magistrate, agrees and says, okay, there's no basis for continued confinement, the soldier is released.
Isn't it true that it's very difficult to prepare for trial when your client's in pretrial confinement?
Extremely. Mainly because the pretrial confinement facility is usually somewhere that's not convenient to get to.
Whose responsibility is it to help the soldier prepare for trial? Is that the soldier's responsibility, the defense counsel's responsibility, or the command of the soldier?
Well, in the context of the pretrial confinement, it is the command's responsibility to get the soldier access to defense counsel so they can adequately prepare for trial. In practice, that sometimes happens and sometimes doesn't.
So is there anything that prevents a soldier who's in pretrial confinement from reapproaching their command and asking them to reconsider, or reapproaching a military judge and asking them to reconsider?
You know, they can always do that.
Right. And they would use the same three bases, right?
Right.
Not going to commit future crimes, not a flight risk,
Right.
lesser means of restriction have not been attempted.
Right.
If you or someone you know is facing pretrial confinement and you want to petition for release, contact a lawyer as soon as possible. We are the law office of Will M. Helixon, your warrior advocates. You defend the nation, we defend you.